have her go live.
Yeah, I already told her.
Okay.
Good morning, everyone. Welcome to the Ag Committee meeting, the first one for the year. And my name is John Winter, the chairman, and I have a great committee assembled here, and I am grateful for that. I want to welcome all of you here and just let you know that we're excited to conduct this meeting and get some of the business for Wyoming done. So first of all, we have the roll call by the secretary.
Representative Banks?
Here.
Representative Davis?
Here.
Representative Eklund?
Here.
Representative Johnson? Representative Ottman?
Here.
Representative Provenza?
Here.
Representative Schmidt?
Here.
Representative Strzok?
Here.
Chairman Winter?
Here.
Thank you.
I'll just explain the rules a little bit. Most of you are probably pretty familiar with what goes on here and the procedures. Let's see. There are hard copies out in the lobby, out in the hallway relative to the agenda. And if you need one, why, and there's none out there, let us know and we'll try to accommodate. So this is just a reminder to expect everyone in attendance to be treated in a courteous and respectful manner. And I think you all understand and have followed those rules, so thank you. I guess one of the main concerns is that the people testifying address the chairperson at all times. So our first bill for consideration this morning is House Bill 91. It's entitled Eminent Domain Energy Collector Systems Amendments. It's a committee bill from the interim. And so I'm going to let Representative Eklund explain a little bit about this, if you would, please.
So a little history on this bill. We ran the bill last session. I'm trying to remember whether it was during the general session or the budget session. It doesn't matter, but it passed through both houses, went to the governor's desk, and then was vetoed. The reason the bill is controversial is because when you take away the ability of government and entities to for eminent domain, which means they can condemn property, land, and what have you to get things done. It's something that we need in government. We believe we need. The first time I ever saw this bill was, and it's over collection lines, mostly with wind chargers. They're probably the same thing with other forms of so-called green energy. The first time I saw it was, we were in the Jonah Center, and I believe, might have been 10 years ago, 12 years ago, and we passed this bill, and it was signed into law, and we went through 10 years of the inability of power companies to use eminent domain to set up the collection lines. And it went without problems. Even though we had imposed this, neither side really used it, as I recall. And now here we are again. It was brought to us over an incident that was mostly, I think, in Weston County, northern Niobrara, Weston County. And the few things that happened that weren't particularly good was the state of Wyoming was brought into it as if we we were going to run these power lines through people and through state land. And they quickly defended that they were not involved in it. The state of Wyoming wasn't. So as this backpedaling happened, and anybody who wants to can correct me on my recollection of this. I should have probably paid more attention to what actually happened. But the companies involved that were wanting to put in these wind chargers apologized for the way it was presented. I guess that'd be a good way of putting it. And then tried to go forward. By then you had representatives of various factions, especially in that little block of Western County where this thing was going to go in. So they brought back this bill that to impose a moratorium on collection lines in Wyoming and extend that moratorium. So I hope I've adequately and accurately explained it. And I don't know if I need to read through the bill. I think the history of why we're here is probably more important than any other part of it. I normally would not be too excited about stripping anybody of the ability to do eminent domain because we don't do it often in Wyoming. As was shown when the moratorium was in place. But as it expired, there were people that became very concerned with what we were going to do. So that's probably my best explanation of the bill and why it's here and a bit of history on it. So.
Representative Banks.
Yeah, just to add to that explanation of Representative Eklund there, Mr. Chairman. Also on a part of this bill, we talk about easements and making sure that an easement that is in place is honored in that the easement that was crafted back then. So there's an easement across somebody's property that was for a specific purpose. And we want to clarify that nobody can come in and put a collector's lines across that easement unless what was agreed upon in their first easement was that they could expand it, or they could add other things to it. But we were just offering some protections in the latter part of this bill that nobody can come in and use an existing easement without agreeing upon by landowners and the holders of that easement to add anything to it. So just another added level of protection there for our landowners that might be involved in something like this with the collection lines on easements and such. So just wanted to add that.
Thank you, Representative Banks. Anyone else here got questions or thoughts? Representative Provenza.
Thank you, Mr. Chairman. Yes, I'm looking at the bill that was vetoed, and I'm wondering if someone on the committee could give me an overview of potentially the difference and why, we're targeting one kind of, I guess, type of industry instead of just trying to fix our eminent domain across the board for anybody. Any clarification on that?
Go ahead.
Yes, thanks, Mr. Chairman. So my recollection is that this is different than the one that was vetoed. This is the bill that, under my recollection, we crafted before last session, the budget session, and it didn't make it to the Senate in time. It passed the House, but didn't make it to the Senate in time. And it's my recollection that it does include all types of energy and their transmission lines, collector systems. I think it's kind of an all-encompassing thing. We started off, I think, with just wind, and then we expanded it to Yeah, for the erection, placement, or expansion of collector systems associated with commercial facilities generating electricity. So I think we kind of did expand it, but happy to answer your questions further if you have them.
Okay. Anyone from the audience here in favor of this bill? If they are, would they please come forward and give their testimony? Anyone against this bill? Please come forward.
Good morning, Good morning, Mr. Chairman, representatives of the committee. My name is Jeff Pope. I am a partner with the law firm of Holland and Hart. I'm here today on behalf of American Clean Power in opposition to this bill. I've been asked to testify because this bill represents the intersection of two areas of my practice. One is I do represent companies in eminent domain actions. Those have exclusively been in the oil and gas sector. And second, I do a lot of permitting and development work for renewable and other forms of electric generation, meaning I interact with the negotiation and acquisition of land for the project proper as well as for collector systems. And I did have the opportunity to testify before the joint version of this committee in the interim on similar bills, not quite this bill, but similar bills in the past. And the problem with this bill largely remains the same as it did, say, a year or two ago. And that is, I think as Representative Eklund actually illustrated, it's a solution in search of a problem. The renewable industry has never used the power of eminent domain to condemn for collector systems. And I am in consultation with American Clean Power and its members. We could not find any data to suggest that condemnation has ever been used. As I mentioned, it's been used in the oil and gas industry. I have been a part of those cases. And in fact, the only condemnation case that I'm aware of that currently is going on in Wyoming is a public utility condemning some land here in Laramie County. So that may beg the question of, well, if they're not using it, who cares? We can pass this bill and everything is going to be fine. Here's the issue. Condemnation is a necessary development tool. The existence of it is necessary to deal with holdouts who may try to prevent a project. And frankly, I will tell you that the folks that I work with view it as a necessary evil. It is an option of last resort. They don't want to use it. In fact, the companies who I've represented in eminent domain actions spent years trying to negotiate a resolution before they came to us and said, we need to pull the trigger on this. But what eminent domain represents is an ability to deal with unreasonable holdouts for a project. So let me give you an example of what I mean by an unreasonable holdout. One of the eminent domain actions I was involved in involved an oil and gas company trying to expand its surface access rights so they could build some more pipelines, some roads, and some well pads. The landowner in that case went back and forth for years. My client made an offer of about 4 times the fair market value of the entire property that this person owned. Not the section they wanted to take, but the entire property. The counteroffer from that landowner was $1 billion, which at that time represented, to put it in context, a quarter of the state's GDP. So what do you do in that scenario if you're trying to develop a project and you have someone who just doesn't want to negotiate? Eminent domain is your option of last resort. Now, with that said, I understand that the plight of an oil and gas company or an independent power producer may not be the most sympathetic thing in the world. So what I would ask you to look at is, what about other landowners? Because collector systems often span multiple property owners. And you really only get into the situation where you need to use eminent domain if you have one holdout. Most of the time, you move along, you secure your land rights for several, and then you have one holdout. If that one holdout doesn't face the threat of condemnation, then not only do they have veto power over the project, but they gain veto power over the exercise of a landowner's private property rights, someone who's already signed an easement or given an option to secure an easement. That compensation and that exercise of their right is now subject to the veto power of the person who doesn't want the project to go forward. So on a macro level, what we are enabling is we are allowing someone who, for whatever reason, doesn't want a project to move forward to gain a whole set of additional rights that they don't have. Now, with that said, I don't want to make it all doom and gloom. There is actually a positive side to condemnation. And I've said this to multiple groups and they all look at me like I'm crazy, so let me try to explain why I'm not crazy. The way the Wyoming system is set up, many landowners actually insist that companies begin the process of condemnation because it provides them benefits. The first benefit is it removes whatever deal they sign from being considered fair market value. Under our law, if I'm under threat of condemnation and I execute an easement or whatever other land document, whatever I get paid is not considered fair market value. So I don't have to worry about setting a precedent for my neighbor or for myself in agreeing to whatever that price is. Second, going through the condemnation process, landowners actually are likely to increase the potential compensation they would receive. Because the legislature back about 10, 15 years ago included what we call the comparable easement approach to valuation as a method of measuring fair market value. And in practice, what that is allowed is rather than just saying, what is my land worth before the condemnation, what is it worth after, I can say, well, wait a minute, my neighbor for this type of project got an initial payment and an annual payment. I should get that too. And now under our system, they can. So what condemnation actually allows landowners to do is unlock more compensation. And I will tell the members of this committee, I have been involved in negotiations where the lawyer on the other side says to me, look, you're making a reasonable offer. My people want you to condemn. Send me the letter. I know that sounds weird, but it actually is how it's playing out in practice. So when you take all that into account, it's bad for both sides of the equation to take this away. And as Representative Banks noted, the way the bill is drafted, it wouldn't just affect wind. It would be anyone who would use collector systems. So that's wind, solar, natural gas, coal, nuclear, any form of electricity generation would be on the chopping block with this. Now, with that said, I do want to talk a little bit about the additional elements that are in sections D1 through 3 in the bill, and that's part of section 1. So first and foremost, the easement protections that Representative Banks referenced are the law as it stands today. If you have an easement, you cannot do anything that that easement doesn't allow. You cannot go beyond the parameters of what is set out in that easement. Now, in prior discussions I've had with the Joint Committee in the interim, one of the concerns that was expressed is, well, we want to try to make it so that someone doesn't have to go to court to have a court say, you violated the terms of your easement. This doesn't change that reality. In order for someone to protect their rights under an easement, they have to go to court, whether you're saying by the terms of the easement, by the common law concept of overburdening an easement, or by statute. You have to go to a court and the court has to rule in your favor on that. So this doesn't change that. But I would urge the committee to reject this language in particular, because what it does is it has the legislature and the state intervene in the private negotiations of parties. It says what they can or may have to agree to. I think we can trust private parties to figure that out. And I will tell you, having been involved in negotiations for over a decade with landowners in all parts of this state, the myth of the small, unsophisticated landowner is exactly that. It is a myth. These are sophisticated people who know their rights, who are well represented by talented attorneys. They are well protected by the law as it exists today. We don't need to reach in and try to change that. The other thing I wanted to flag is subsection D, Romanet 3, which deals with imposing reclamation requirements in a condemnation case. This again is already the law. Wyoming Statute 126-714, which is in the Eminent Domain Act, requires certain reclamation when you receive an order granting a property right that you have taken as part of the eminent domain process. So that's already in the bill, in the law. The other thing that I would note for the committee is Wyoming Statute 126.510, which is also in the Eminent Domain Act, sets out what is required to be in what we refer to as your initial and your final offer letters. That's the negotiating process that precedes an actual court case to condemn. In that statute, there are requirements for you to present a reclamation plan to the landowner. So we have a multi-level system, a multi-level protection system where reclamation is accounted for. So again, sections D1 and D3, they are already the law. Happy to stand for any questions.
I'd interrupt for a minute. You're on D, and I don't think we have a D in my bill. Are you on C?
So as I'm,
Must
and
be.
Mr. Chairman, Representative Eklund, as I'm looking at, and I apologize if there was some changes made overnight, as I'm looking at the bill, there's a section 1, and then it's amending Wyoming Statute 126.815D. So when I reference D, that's what I'm referencing.
I see.
So Mr. Chairman, I guess I will close with, on behalf of American Clean Power, we would ask the committee to vote no on this bill, and I'm happy to stand for any questions.
Is there any questions for the committee?
Oh, go ahead.
Go ahead, Representative Bodman.
Thank you, Mr. Chairman. Good morning. Very interesting. I have a couple questions just because I'm not familiar with this and I was not at those committee meetings or the interim. So what I'm wondering is, I believe I might have heard that something's expiring, and so this is being put into effect. The other thing I was wondering is, are you representing and speaking primarily on public utilities or private business? And also, when they look at this and are looking to enforce eminent domain, is there a way where if this doesn't go through, that municipalities can make those decisions for the areas that they supervise?
Mr. Chairman, Representative Ottman, thank you for the question. I'll start with the utility private company question. I'm here on behalf of American Clean Power, which is the trade association representing independent power producers, so non-utilities, primarily in the renewable space. But as I mentioned, this bill would preserve the right of a public utility to condemn for an energy collector system. That wouldn't change. So what this is doing is, in the status quo, a private company, excuse me, can exercise the power of condemnation to condemn an energy collector system. This would remove that for a private sector. So if I'm a company that wants to build a wind farm, a solar farm, a natural gas plant, coal plant, a nuclear reactor, and I need a collector system, this bill would say you can't condemn in order to acquire the rights necessary to build that collector system. In terms of the sunset question, yes, I'm a little hazy on the history, I apologize, but I do believe the prior moratorium expired a few years ago, and this bill was bringing that back. Finally, in terms of the process for a municipality to get involved, municipalities historically have never been involved in the condemnation process. The way it works is our Eminent Domain Act requires a period of good faith negotiation between the party who may condemn and the landowner. And there's requirements in statute for what they have to negotiate over, what has to be included in what we refer to as the initial and final offer letter. That has to last for a certain period of time. And then if that fails, if the parties can't figure out a resolution, then say the power company here, they can initiate a court case where they seek to condemn a portion of that property. And the Eminent Domain Act bifurcates that process into what we call the takings phase, where a court says, yep, you have proven all of the elements to take possession of the property, which under statute, you're only taking an easement right. You don't actually take the property in fee where you would own it outright. And then after that, you go through what we call the compensation process, where you have either a jury or a judge determine what is the fair market value of the property you took, and then the party who condemned pays out whatever that award is.
I don't know if you're the right one to ask this question. Are you involved with the one the little problem we started up with this deal in Weston County? Are you familiar with that?
Chairman Winter, Representative Eklund, unfortunately, because I'm a lawyer, I can't disclose who I
okay.
don't represent, but I can tell you that I am familiar with the company, the project, and kind of the genesis of all of this. So I can't disclose whether I represent them or not, but I am familiar.
Yeah, Mr. Chairman. So this isn't in the bill, but you brought it up, so I'm going to go ahead and discuss it. You talked of the landowners receiving a spread out pocket of money for the project. Can you explain that, how that happens? Starting with those that have wind towers on them down to those that have collection lines only.
Mr. Chairman, Representative Eklund, I'd be happy to. So there's a couple of ways in the development cycle that a landowner can receive money. The first is what I would refer to as the option period. Most of these projects, when you're building whatever you're building, you have a number of surveys that you have to do before you even decide, I'm going to put my project here, or I'm going to put my collector system here. You go to that landowner, you say, I'd like to get onto your property to do some, what are largely environmental surveys. Sometimes they're geotechnical. You would pay them for the right to do that. So that's compensation area number one. Then if you decide that that landowner, you're either going to build your project there or you're going to run a collector system through there, you would very likely go back to them and say, okay, we would like to get an easement from you in order to put whatever infrastructure out there that we want to put. You would pay them for that easement, because even though an easement is a property right, 99% of the time it's created by a contract between private parties. And so they would receive compensation that way. If a landowner says, no, I don't want your project out here, but that company decides I have to put it on that land for whatever reason, and there's a variety of reasons that may dictate that result, they would then, if necessary, begin the condemnation process, where they would negotiate. They've got to make an offer. There's certain elements that have to go in that offer by statute. And if they can't agree, a court case begins. Part one of that court case is a court saying, yep, you have proven the elements under the Eminent Domain Act. That easement is now yours. So then we get to the third way you can get to compensation, which is once you have taken possession of someone's property, there is a separate court case that determines the fair market value. And our statutes in the Eminent Domain Act set out a couple of different ways you can measure fair market value. One is what we would refer to as the traditional before and after method. What's it worth before I took it? What's it worth now? That is almost never used after the legislature amended the act to allow for the comparable easement approach to valuation. That valuation is looking around at your neighbors going, okay, my neighbor signed up for an energy collector system and the compensation for that was X. Other neighbors signed up for it, that compensation is Y. I should get something that looks like that. So that is largely, I don't know how many of y'all are football fans. The way I explain this is it's kind of like a quarterback contract in the NFL. The next guy up looks at the last guy and goes, okay, I want what he got plus $1. That's largely what comparable easement approach to valuation ends up looking like.
Follow-up. So you're kind of getting to what I want to know. My recollection of all of these, especially wind towers, I know we've got solar units, solar panels going in here and there. The compensation package is almost always whoever has a wind tower on their land gets compensated beyond the easement in an annual or monthly payment or whatever. The people with the collector lines are given hopefully a healthy easement to begin the thing without any compensation for the years of putting up with these collection lines. And I guess if I'm incorrect on that, you can straighten me out, but, and if I'm correct on it, I guess I'd like to know if the power companies have any plan to do what you said, and that is spread out the compensation for this project, which involves all these landowners, and it's why we're here today.
Mr. Chairman, Representative Eklund, as a matter of fact, you're correct generally that the landowner where the wind tower, the solar panels, the power plant, if you will, where those are located, they tend to receive a greater amount of compensation because there's a greater amount of disturbance and interference with their land. But if I need your land to run a collector line on, I have to pay you for that. Because an easement, as I mentioned, is a contract. If I don't have what the law refers to as consideration, which simplified as money, then that's not a valid contract. It's not a valid easement. So I do have to pay for that. And so more often than not, the way that compensation gets measured for collector systems is typically either on a per acre or there's various other measurements like linear foot or a rod. But essentially you would say, I'm going to pay you $10 a rod for this collector system. So if I have 1,000 rods, which is 16.5 feet of collector system on your land, I'll pay you 10 times 1,000. And that could be a one-time payment. It could be an annual payment. It just kind of depends on what the parties want to negotiate.
Mr. Chairman, so are there any of these in which you have an annual payment for the people with the collector lines? Because this deal that we're in today is a whole lot different than when rural electric came into the country. It came in just before I was born, so we're looking at 70-some years ago. And when they came in, people heard that power lines will go in and you'll have electricity. They gladly let the power lines go across their property to get what they knew that their cousins had in town, which was power and electricity and the conveniences, refrigeration, showers, all the goodies. This is a whole different deal where you've got more power lines going in and the compensation from what I've seen just simply isn't fair. And the question I asked was, are there any collection systems, including the collection lines, in which the people are being paid on an annual basis, right along with the wind charger, the ones that have the wind charger on their property?
Mr. Chairman, Representative Eklund, apologies if I misunderstood the question. The answer is yes. I am aware of gathering systems, collector systems, as they're called a couple of different things, where there are annual payments. It really depends on what the particular development company wants to do, but in some instances, you have landowners who say, you know what, you can build that transmission tower and that collector system for a one-time payment because I can still use most of my property, right? It's not as intrusive of a footprint and disturbance as some. Now, others say we need both an upfront, which we call an initial payment, and then I need an annual rental payment. And so, yes, there are for collector systems, landowners who receive both an initial payment and an annual payment. I don't have the data, unfortunately, on how often or how many times that occurs, but at a minimum, in order to secure that land right, they are going to receive some compensation. They have to.
Thank you, Chairman. I guess my one thing to understand this, so you would be okay with someone not having their property rights. Is that what it is? If we don't sign this, anyone can say, look, I don't want this coming next to my house. I don't want this line. I don't know any of this. And that is their property and they have rights. But this, what you're saying, it's okay to take away these property rights as you've paid for the land, you're paying on it and it's yours.
Mr. Chairman, Representative Strzok, again, I think the way my clients would characterize it is it is oftentimes a necessary, I shouldn't say often, it is a necessary evil sometimes. So yes, what ends up happening with condemnation is a landowner who owns their land has an easement taken from them and given to another party. And what the Eminent Domain Act, in my opinion, represents is an attempt to strike a balance between the right of a private property owner to exclude someone from doing something on their land, but balance that against the need for some kind of project that creates a larger benefit for the public. And the reason I say that is when I refer to the elements that you have to prove to take property. One of those elements that you have to prove by statute is that the project is in the public interest and necessity, which means that it's not, I'm just going to make some money for my company. It is much broader than that. So the way our courts have interpreted that portion of the statute is it's largely for energy generation projects, that everyone benefits from the creation of energy, the extraction of oil and gas, whether it's from a revenue standpoint for the state or just keeping the lights on. So what the Eminent Domain Act says is, if we have a project that is going to create a public good, we will not allow one person to stand in the way of that. And the way to balance the admittedly negative aspect of it, of taking the property right, is you don't take ownership outright. You take an easement. And then once you're done, you reclaim that easement, you reclaim all the infrastructure, again, by statute, and the property, all of the property rights, if you will, return back to the underlying landowner.
Thank you, Mr. Chairman. I promise my name will get easier as it continues to roll off your tongue. I'm thinking, to Representative Strzok's question, talking with landowners in Albany County, a lot of them are folks that have had their ranch for generations, for 5 years. And many of them have wanted to have some sort of development. In the case of Albany County, we're talking about wind energy, because it allows them to keep their land. They're not able to raise the funds that they need to manage their property without having some other source of income, because ag is not bringing the financial gains that it once has. I guess in these cases, what I'm wondering, is it who the person who's holding out? Maybe it's one person who's holding out. But aside from the public gain, in Albany County, it could be, if we had transmission line, it's like you've got several people out there that are billionaires or millionaires that don't need the money. And they could potentially infringe on the rights of the other property owners to try and keep their ag land. Am I understanding that correctly in where this could potentially be beneficial for the multi-generational Wyoming hardworking ranchers? Is that a case that is that something that just happens once and never again, or is that something that is more likely?
Mr. Chairman, Representative Provenza, the answer is, I think you've hit the nail on the head, and I'll give you an example from right here in Laramie County. There was a solar project that I worked on where there were 3 landowners. They were multi-generational agricultural ranching families, and the solar project represented a way for them to keep their land. The ag business was going south for them. This company came in and said, we'd love to lease your land to build this project. They said, fantastic. They signed a deal, and now that land will remain in their family. And the point I was making, which I think you encapsulated nicely, is if I need some money, I sign my land up for a collector system or maybe for the power generation source proper, and somewhere along the way of the collector system, someone says, nope, and there's no right of condemnation, that no vote is now a veto over the entire project, as well as on the landowner who may want or even need the compensation from a collector system or the project proper.
Thank you, Mr. Chairman. Can you enlighten me, I guess, on the different, Representative Strzok down there brought something to my mind on the different types of what we're calling collector systems where we're going from, say, a generating section to a switch gear, or, where we tie into the. So what are the different types of collection systems that we're looking at? Overhead, underground,
Mr. Chairman, Representative Davis, largely what collector systems are, and the statute does, excuse me, define that to a certain extent, but largely what we're talking about is overhead transmission lines that run from, say, a central gathering point, a substation that's on the power generation site. So let's use solar as an example. You've got all those panels, you've got gathering lines from each panel that run to one, maybe two collection points, substations on the project site. And then you've got transmission lines that run out to largely a utility substation that then will connect into the larger grid and can get dispersed. So when we're talking about collector systems, that's the primary, the overhead transmission is largely what we're talking about. You could do underground, but from what I understand in talking to the clients that I work with, that's largely not very cost effective. So it's predominantly overhead power.
Thank you, Mr. Chairman. Another question is, the right of condemnation, is that sometimes the preferred alternative to, say, if you're having, say there is a no vote and you have to reroute and have to go across, say, public land, BLM and stuff like that, and you have to run through the NEPA and that process and the expense of running down that and the delays and times. So isn't condemnation sometimes used to speed up the project and et cetera? Is that correct?
Mr. Chairman, Representative Davis, that is a scenario that projects encounter where they may get a no vote or I don't want you on my land from someone, and the possible reroute of a transmission tower would put them on BLM land. That does create the scenario of going through NEPA, and I think we're all well aware of how difficult and time-consuming and costly that process is. So I don't want to say that scenario doesn't exist, but I am not aware of a company ever using condemnation to avoid that scenario. I certainly would imagine that if that scenario arose for a company, that they would consider or look at condemnation. And there's some companies, frankly, that wouldn't. I have one client in particular who we were talking through condemnation at one point because they just wanted an overview. And after I was done, they said, okay, great, we're never going to talk about that again because I'll get fired if we talk about condemnation. So I don't want to say that scenario doesn't exist, but I'm not aware of condemnation ever being used to deal with it. And in fact, the only instances of condemnation that I've been a part of and the cases that I've researched in my practice, none of them have involved that scenario.
Okay, go ahead.
One more, Mr. Chairman. The reason why I bring that up is, predominantly, the state of Wyoming has got a lot of BLM and federal ground in it. So that's why I'm saying that has to be figured in there, maybe not on one side of the state, but definitely on the other side of the state,
Mr. Chairman, Representative Davis, no doubt, the difficulty of constructing and permitting on, in particular, federal land is enormous. I have a project that is entering year 8 of the NEPA process when they were promised it was going to be 2 to 3. So yes, and frankly, condemnation would be a tool potentially to address that scenario, to avoid public lands, condemn maybe a small section of private property. So yes, that is, I guess depending upon your outlook, a value add of having condemnation in your toolbox.
Thank you, Mr. Pope. We need to move along. Is there anybody else got a question? Okay.
I would have it. I'm sorry, Mr. Chairman, I don't mean to hold this up, but I'm going to correct you a little bit on what happens upon the expiration of these easements. And granted, the new easements are probably going to have attorneys and hopefully they'll be better than they used to be. But in many parts of the country, when a railroad was removed, those places became walk trails for people to take their dogs and through the middle of folks' property. We haven't had that happen in Laramie County that I know of. Maybe we have, but the missile lines, I've got those running through my own property when the time has expired and or the retirement of some of these missile bases, it didn't go back to the landowner. It went up for auction for anybody to take over. Atlas was that way. Minuteman is exactly that way. We've even got a state park right in the middle of some people's ranch, just north of here. And one power line going through your property usually will bring in several more. My REA provider representative's right back there, and believe me, I am grateful, very grateful for what we get out of power. But I think we need to know why exactly we're kind of fighting for landowners and their ability to maintain control of their property, and for that to happen generations later. And generations later are living with some terrible easement plans, and we just don't want that to happen. The expiration of my easements just involved more complications.
Mr. Chairman, Representative Eklund, no doubt there are some situations that you've outlined, as well as some very, very old perpetual easements that are out there that are very vague. And those often do create problems. In fact, I've litigated those on behalf of landowners. The point I'm trying to make is that the law as it stands today says that if I have an easement that says you can do X and Y in that easement space, that's all you can do. You can't do Z. So to borrow from the bill, if I have an easement that says you can build one collector system, that's all I can build. I can't build a second collector system. Now, if I attempt to do so, you can sue me, and a judge would very likely find that I have breached the terms of that easement and I can't move forward. And I understand the desire to maybe provide greater clarification or try to embed in statute that concept. But in practice, what that still results in is I, as the landowner, have to go sue someone and say, hey, you've either breached the easement or you violated the statute. So it doesn't change the practical consequence. And given that the law already says, not only that can you not breach the terms of your easement, you also can't overburden your easement, which is a slightly different concept. And so let me give you an example of that from a case I litigated. There was a rancher who had given a water district an easement to travel a road so that they could get up to and build and maintain part of their facilities. And they did that for 2 decades. And, it was a truck coming up occasionally. And then they decided they wanted to expand and build additional facilities, and so they started running construction traffic through there. And yeah, they could use that road for the maintenance of their facilities, but the law says, well, wait a minute, they didn't contemplate at the time of that easement brand new construction and construction traffic. And so the court, we settled, but the argument was that's overburdening the easement. Yes, you can find some language in there to support what you're doing, but you're going too far. So the law already has those protections in place. And so the point I'm making is, as a legislative body, the state doesn't need to reach in and try to govern those situations.
Thank you.
Thank you, Mr. Chairman.
Mr. McDagnon.
Thank you, Mr. Chairman. Jim McGagnon with the Wyoming Stockbrokers Association. I will try and be brief here. I do want to just raise a couple of key points in the history of this because I've been involved in it from the beginning. And in 2010, this issue first arose when wind energy facilities were first coming to Wyoming. The consensus then, meeting with this very committee, was that not that we necessarily wanted to preclude the use of eminent domain, but we needed some time to figure this out. So that's when the language that exists today was drafted that said a prohibition initially for 2 years, and then it was extended for 3 more years. Then it just kind of didn't receive any attention because we went through a rather lengthy decade in which wind energy wasn't appearing on the surface in Wyoming anymore. It wasn't being pushed forward, and now we're back in again, where of course it's very widespread. So that's one thing that I believe is important. So when the Joint Ag Committee took this up at the interim this past year, after the one bill had been vetoed, we brought a bill to the committee that had actually been drafted back in 2012, but never introduced because the issue kind of went away, that provided that, not an absolute prohibition, but provided an entity could not use eminent domain until they had negotiated voluntary agreements with 85% of the impacted landowners on 85% of the impacted land. So whatever the length of that need for that collector facility was, you had to negotiate without eminent domain with 85% of each. And that was a bill that we strongly supported. We felt it recognized that an absolute prohibition means that one landowner with perhaps just a few hundred feet that the line goes across them can prevent a whole array of landowners who have found this to be beneficial to them from being able to take advantage of that. On the other hand, we felt it dealt with the issue, which I have seen examples where companies have sent letters to landowners at the very beginning and said, if you don't agree to our proposal, we will consider using eminent domain. That threat is not acceptable. So we felt that was a good balance. That bill was worked by the committee, as the members on here who were there are aware of. And at one point, the thought was to bring both bills forward to this session for discussion and debate. Then at the last joint committee meeting, and Mr. Chairman, if I'm wrong, correct me, but certainly it shocked us when the committee suddenly voted to just bring forward the absolute prohibition and to not bring forward the other bill, which provided the 85% and give the legislature the option to look at both of those. So we are concerned with this for that very scenario. It is a matter of balancing private property rights. But my private property right says if I reach a satisfactory agreement to do something with my land, I ought to be able to do that so long as I'm not negatively impacting other property owners. And we feel that you seek that balance. And if you go to the extreme, which we believe this bill does, that says that one property owner can prevent 20 other property owners from enjoying the benefits of something that's been proposed to them, that's going too far. Go to the other way and allow them to use eminent domain against everyone, that's clearly going too far in the other. So based on that, seeking that balance is where the bill came from that was in front of this committee, and at the last meeting was, frankly, it shocked us when it was not brought forward. And for that reason, we think we need to achieve that balance and would urge that this bill not go forward and that we take the time to look at that more flexible option to go forward in the future. The second part of this bill, the part beginning on page 3 with line 4 of all the different considerations, we don't have any problem with that. I tend to agree with the previous speaker that that's generally already covered in law. There's no danger perhaps in repeating it in this section of the law, but certainly the first part of the bill, the absolute prohibition, is something that in the interest of all landowners, Wyoming Stockgrowers Association does not feel that we can support today. With that, Mr. Chairman, I'd be pleased to take any questions.
Thank you, Mr. Chairman. Mr. Magagna, good morning. Do you believe that currently there is in place the provision for reclamation if, like, say, a wind farm comes in and then the transmission systems age out and there's not a company there to renew all of that equipment? What happens then?
Mr. Chairman and Representative Ottman, as to what is there today, to the extent that these are privately negotiated agreements, obviously the terms of the agreement are going to determine what the reclamation responsibility is. We certainly work with landowners and encourage them to make that a major area of focus when they're negotiating a right-of-way, to assure that there is assurance that reclamation will be completed. Under many parts of our law, there are bonding requirements which address that. I would certainly say that that's an issue that perhaps could deserve to receive some further discussion and exploration as to whether we need anything further in statute to provide those assurances. But for most landowners I know, reclamation is a critical part of any negotiated agreement that they enter into. And just that brings back maybe to the 85%. One of our thoughts there is that if you've had to negotiate successfully with 85%, then you have to offer that reluctant landowner that you're proceeding with eminent domain on at least equal to what you did with those other 85%. So if they've negotiated favorable agreements from a landowner perspective, the person who holds back and requires eminent domain is in a position to receive those same benefits.
Thank you, Mr. Chairman. Good morning, Jim.
Good morning.
I have a question for you, and it just kind of, with the conservation easements, and I know you're pretty familiar with this, how would a moratorium like this affect them? Would the right of condemnation still be a tool if the land that you're going to cross is within a conservation easement?
Mr. Chairman, Representative Davis, a good question to which I don't have a firm answer. Certainly the conservation easement could preclude the landowner from voluntarily entering an agreement for a right-of-way, depending on what the individual terms of the easement are, because the landowner is obligated to protect the conservation interests that are contained in the easement. In a condemnation proceeding, my expectation would be that would enter into the discussion. So if there's a condemnation, the requirements that would be imposed on the condemnor would include, to the extent possible, provisions that would keep the easement, the use of the easement, consistent with the terms of the original conservation easement. Yes.
Thank you, Mr. Chair. I just wanted a clarification on that.
Okay, thank you, Mr.
Thank you, Mr.
McGagnon.
Chairman.
Is there anyone else wanting to testify in favor of this bill? Yes, ma'am.
Thank you, Mr. Chairman. I didn't realize that you were going to call for in favor. So if you want me to not testify, I'm not in the in favor category. So if,
Well, that was my mistake.
okay.
Go right ahead.
Mr. Chairman.
You're against
Thank you, Mr. Chairman. Members of the committee, my name is Cindy Delancey. I'm an attorney with Holland and Hart, and I'm here on behalf of the American Clean Power Association. I just wanted to take a moment. I know we're running short on time, but to address Representative Ottman's question as related to reclamation and to build on Mr. McGagnon's comments. I felt compelled to speak on this because this is a topic that's near and dear to my heart, as when all this was happening back in the 2010 era, dating myself a little bit here, but I was instrumental on behalf of Carbon County in writing the statutes that we currently have on the books related to reclamation of these types of industrial projects, specifically related to wind. It's something that is a concern as a landowner myself, as well as the governments, and who's going to be left holding the bag. And the answer is that that no one is going to be, that protections are in place by the DEQ through the regs of the Department of Environmental Quality. Not only, as Mr. McGagnon noted, is bonding required on these projects, but there's also the requirement before a project can be approved for a reclamation plan that's thoroughly examined not only by the department staff, but also the Industrial Siting Council. So I'd be happy to provide you with that language after the hearing today, but just wanted to give you the assurance that these issues have been really looked at over time to a place that Wyoming, I feel, has a very responsible and robust approach to making sure that projects are reclaimed in an appropriate manner. So just wanted to address that, Mr. Chairman. Thank you.
Thank you. Anyone have any questions?
Thank you.
Is there anyone else wanting to testify relative to being opposed to this bill? If not, Is the Miss Campbell on the Zoom? Okay,
She is, yes.
let's go ahead and invite her in.
Okay.
Thank you, Mr. Chairman. Can you hear me?
Yes, ma'am, we can. Go
All
ahead.
right, thank you. Thank you, sir. Thank you, Mr. Chairman, members of the committee, for the opportunity to be here with you today virtually to talk about House Bill 91. My name is Kelly Carpenter, Policy Advocacy Director for the Wyoming Farm Bureau Federation. I'd like to speak on behalf of the Wyoming Farm Bureau membership in support of this bill. Our policy set by our membership supports limiting entities, especially those that don't go through the Public Service Commission to obtain a certificate for public convenience and necessity, from being able to use the power of eminent domain. We favor and encourage companies to develop in existing corridors and explore alternate routes or bearing infrastructure, so projects may go forward instead of tipping the scale against landowners that don't desire the development through their property, because that is their right as well. We are unaware of any situations where those with the infrastructure on their land are having annual payments similar to those that house the towers, but would be supportive of that in eminent domain cases, specifically in reference to wind projects. We believe this bill is a step in the right direction for protecting private property rights from our membership's perspective. Thanks again for the opportunity, and I'll take any questions you or the committee may have.
Thank you, Ms. Carpenter. Anybody have any questions? Okay, well, thank you again.
Thank you.
Is there anyone else wanting to testify? Representative Tarver, you declined? Okay. Well, thank you all for coming. So what's the pleasure of the committee?
Move to pass.
We have a second? We have a motion and a second to pass this bill. Do you have any discussion on this? Representative Davis.
Mr. Chairman, after listening to some of this testimony and stuff out here, I'm gonna probably be a no vote on this because I don't think this bill quite addresses everything that we need to do. There's too many loopholes, for instance, with the gathering, the natural gas, which we have just barely touched the surface of it and its electrical gathering and et cetera, and transmission and what the future of it may be. So that's where I'll probably be on this one.
Okay, thank you. Anyone else? Representative Eklund.
Mr. Chairman, so I presumed I would be an aye vote on this thing. But as we've gone through this and my recollection of what's happened in committee and what have you, I think there was a better solution to it. This bill is probably a winner-take-all kind of a bill, and the other bill had some concessions in there. I still want to get back to what happens when a lease or an easement, what happens when an easement's in place? We had a landowner group that negotiated a power line that was right down the easement of a major power line, bigger one yet, and the next one was a big one too. That landowner group was left with an ultimatum from the power company. You'll do this or else. And that attitude eventually got to our chief executive's office, and he says, you're not going to cross state land if you don't deal with my people in a fair way. And eventually there was a solution done without having eminent domain. But it doesn't happen in a nice way necessarily. This one did not happen in a nice way. So that's why my heart is saying, vote for this bill. My head is saying, don't vote for this bill, and it's just a tough dilemma that we are in. I can see the position that a company would get into if you had to deal with a hard head like me and others. I'm not the only one around. So anyway, those are my thoughts. If we were to try to resurrect the other bill, I'd be in favor of it, and I still haven't decided how I'm going to vote on this one, which is odd. I usually know what I'm going to do beforehand. But the testimony has been fairly strong on both sides, I think.
Okay, is there any other comments on this bill?
Mr. Chairman.
Yes. Representative Ottman.
Thank you, Mr. Chairman. There has been strong testimony against it. When I read it, pre-read this bill before this meeting, I thought, okay, I'll be anxious to hear what everybody has to say. Since I did not hear a word from oil and gas except from Mr. Pope, I would want to hear how putting this back into effect may affect them. But also, I didn't, as far as land use, county land use, I don't hear how that is, in this bill. I believe that it would be at least considered, as well as the responses to what I've heard from testimony is that landowners have a right, especially smaller ones, to litigate. Well, with huge attorney fees and things like that, I don't think the smaller people are represented, as well as, we've heard that there's large landowners that have owned their property for a while. The data shows that large landowners are taking over and not always for agricultural purposes. There's different things to do as far as like income or tourism or whatever. And the other thing that I was thinking about was that without this bill, there's no consumer protection exactly, or look at it from the Public Service Committee or the land use policies, like I said, in the counties. So really, I'm an aye vote on this.
Thank you, yes. Representative Schmidt.
Thank you, Mr. Chairman. Through the testimony, what I see happening with this bill is no matter which way the vote goes, there's winners and losers. And I think based on that, it's a good place for the government to stay out of it. Let the parties that are involved in these projects work it out between themselves. I don't think the government should be, the state of Wyoming should be involved in this and help pick the winner or the loser in any case. So I would be an aye vote on this.
Anyone else?
Question.
Question has been called for. Could we have the roll call vote?
We're voting on House Bill 91. Representative Banks.
Aye.
Representative Davis.
No.
Representative Eklund.
No.
Representative Johnson.
Yes.
Representative Ottman.
Aye.
Representative Provenza.
No.
Representative Schmidt.
Aye.
Representative Strock.
Aye.
Chairman Winter.
Aye.
The vote is 6-3 in favor. This bill would pass.
Okay, thank you. Our next bill for consideration is House Bill 118.
Do I have to go down to the hot seat?
Probably should. Representative Dalton Banks will present this bill.
Nice. Couldn't we have Representative Harvard who'd do a better job?
Mr. Chairman, thank you. I bring before the committee House Bill 118. And the intentions of this bill, and remember this when you get to the floor because it's very important, this is to keep Wyoming lands in Wyoming hands. and by so doing, limiting the surface and mineral rights, the net gain of surface and mineral rights to the federal government. With this past administration, we've seen the war that they've declared on both those two things, the surface rights and the mineral rights for the state of Wyoming. Things that we use for our livelihood. We see it in the Rock Springs RMP, the Buffalo RMP, that they really don't have the best interest of Wyoming in heart. And I don't think that it's in the best interest of Wyoming that we let them gain more access to our ground. Land that can be used and for the benefit of Wyoming. I also think it's in the best interest of Wyoming that we don't allow just outright sales of state ground. Something that we worked on that's kind of been a hot topic is the sale of the Kelly parcel. Well, what did Wyoming gain from that? We got a one-time payment. And what did the federal government get for that? A valuable piece of property. And there was efforts to do exactly what this bill is trying to do, exchange to gain surface rights and mineral rights both, which would have been a tremendous gain to the state of Wyoming. And had this bill been in effect, and that would have been the case. I believe that we need to make sure that that doesn't happen again, and I think it's our prerogative to make sure that Wyoming land stays in Wyoming hands. The majority of the bill, it starts past the definitions on page 3 that talks about the exchanges. Surface rights and mineral rights is laid out there in statute 36.1.105. We also address statute 36.9.101 that explicitly says no sale of state land shall result in a net gain of land to the federal government. I think it's plain and simple what this bill is trying to accomplish, and I would leave it to the committee on any questions that you might have for me at this time.
Have any questions? Excuse me. Representative Provenza.
Thank you, Mr. Chairman. Representative Banks, do you know how much of Wyoming's lands, state lands, are sold off when we acquire them? How much we've started with, how many of them we've sold off for financial reasons?
As a total number since we became a state, Mr. Chairman, or?
If you have any number, I'm just genuinely trying to understand how many, if the state acquires lands, how often do we sell them off, hold on to them? Like, what do we do with them, regardless of who buys them, if it's federal government or not?
Mr. Chairman, I don't have exact numbers, but the intentions of this bill is that the state will hold on to property unless it is in the best interest that we gain something that's going to be more valuable to us in the long run. What was proposed before the Kelly parcel was sold is that we were going to get valuable property that included surface rights and mineral rights both, and that would have been a value to us as a state. The interests, I think, in this bill are behind just that we retain our Wyoming land into Wyoming hands, not letting the federal government take hold of that, because once that happens, we don't get that back. And then it's subject to things like RMPs and federal rules that more often than not don't have the best interests of the state in their intentions.
Go ahead.
Thank you, Mr. Chairman. Aside from that, does this bill prohibit property owners, like private property owners, from selling their land to the federal government if they so choose?
Mr. Chairman, this bill does not. This just extends in the statutes 36.105 that is exchanges between state land and federal land.
Anybody else? Representative Davis.
Representative, maybe you can answer this, maybe not. You know, a lot of this I hear and have experienced is up there, you know, where we're trying to get the state lands out of the forest and put them to where we can actually utilize them. but there's that word in kind or in value and stuff like that. And I'm a little confused, we have a pristine parcel up there that went out. And then what values as far as minerals or surface value is there? I'm a little confused on how your criteria would be based on this. Is it just acre for acre, or is it you have in there value and stuff like that? That's the only thing I'm not quite grasping.
Mr. Chairman, so in 36-1-110, it gives the director and the board, the State Board of Land Commissioners, the ability to negotiate what that would play out to be. And so the authority resides with them.
Okay, anybody else? Thank you, Dalton, and take your chair up here again. Do we have any testimony from the audience? You state your name and who you represent.
Mix up the two rooms with the lights. Thank you, Mr. Chairman. Megan Degenfelder, State Superintendent of Public Instruction. I'm here today per my constitutional duty as one of the 5 statewide electeds that serve on the State Board of Land Commissioners. I come to you today fully supportive of and appreciative of the bringer of this bill. Number one, because I fundamentally agree in the concept that we cannot continue to increase federal ownership of the state of Wyoming. We already are owned, Wyoming, 48% of surface is owned by the federal government, 65% of mineral acreage is owned by the federal government. We cannot afford to increase that number. But I also come in support of this bill because I believe very much in my fiduciary responsibility on the Board of Land Commissioners, that we maximize return to fund our K-12 education system. The way that we do that is through maintaining our lands and productivity on those lands. Now, when we talk about the Kelly parcel sale, proponents of that sale will say that we did in fact get a one-time sale that can be used as investment, or that money can better yet be used to purchase land. Unfortunately, in this circumstance, we lose all leverage when it comes to working with the federal government. While I am committed to continuing with this process because I believe that we need to offset that 640 acres that we just sold, it becomes difficult. We start talking about valuing, appraising the surface and the mineral estate. We did not appraise the mineral estate of the Kelly parcel. We start talking about favorability of the BLM to simply use disposal lists, which don't do much in terms of developing the acreage that we need to develop those minerals. While we have 4.2 million acres of state land in this state, which to some might seem like a lot, we should be able to develop that. But unfortunately, when that land is contiguous or intermixed with our federal land, it becomes difficult, and I speak to you from years of experience within the oil and gas industry, to create a full play. Needing a 1280 spacing unit to properly develop that acreage. And so thus, as we continue to have a net increase to the federal government, it becomes not only more difficult for us to produce our minerals and therefore produce revenue for our K-12 schools, but it fundamentally puts Wyoming in the hands of the federal government, which it really doesn't belong. And would just close with our Code of the West, that it's important to remember that some things just aren't for sale. And with that, Mr. Chairman, would stand for any questions.
Thank you. Any questions for Ms. Degenfelder?
And Mr. Chairman, if I might, for Representative Provenza, would be happy to work with the interim state land director to look over time since statehood, what that has been. I would, it really depends. Our last meeting, we actually approved a swap where we actually gained additional acreage, but this was between Cheyenne and Sheridan for Volunteers of America. And so there's been a lot of, some of that going on over time. And so would be happy to work with them to get that information to you.
Okay. Representative Eklund.
So I'd have a question on that as to whether there was a decrease of the federal government acres. I'm guessing there probably wasn't. A little history on the Kelly parcel, because I think I was around, and it was about 2011 that one of our top state electeds, it was Joe Meyer, he was treasurer at the time, just appealed to the Ag Committee to to go ahead and sell that thing. And the price tag was 100 million then. And there was agreement that it should just be sold, even though we knew we were getting out of process. We might have state lands address why that, what we did and what we were doing then was out of process. But it was a lot of money, and it meant a lot to our schools to probably have that. If nothing else, I think it was gonna go into a permanent fund, and we were gonna live off of the roughly $5 million a year that would go into the school foundation fund. So this thing has been kicked around for a long time. My own thoughts were that it probably should have just gone to public auction and see what happens. Maybe the federal. I know that would have been wildly unpopular, especially in Teton County, and I hate to do that to them, but that's kind of how maybe it should have happened. I think we vastly undervalued the Kelly parcel and how it could have been used and would have been used. I know it's a great part of the park too, so those were my opinions. I stand in favor of the bill, but I think there needs to be a net loss to the federal government now that they've gained 600 acres. And I know that's not a lot of acreage in the scheme of things, but somehow we've got to be able to do that. And I commend Representative Banks for bringing the bill.
Representative Davis.
Thank you. State Superintendent, Megan. Hey, there's roughly 17%, and that's the private and public, as private surface, public minerals. Is that the one thing we want to try and go after a little bit, the split estate? Is that one that we need to, pinpoint, or how's that, what's your thoughts on that? Where's that sit?
Mr. Chairman, Representative, we discussed split estate for years and years in this body. But I think that in any terms of federal ownership, it would be my belief that we need to go after that and look to see how we can acquire that. I mean, making it easier then for surface and mineral disturbance in doing that. And so to me, I think, I would prefer any way that we can have a net gain for the state of Wyoming in those areas. But that is a problematic issue that we face in all terms of split estate.
Anyone else? Yes, Representative Eklund.
So I didn't quite complete my thoughts. That happens from time to time on the history. And that was where we were going to go. We were going to try to get some useful acres of minerals in other parts of the country. And I think that continued to happen with our land board as well. They would have preferred that. And the federal government didn't play the way we wanted to, so we caved and gave it to them for a mere $100 million, I think. So that's what I wanted to say. That's been something that's been tried. Our state has worked on that, just not successfully, against a federal government who can quickly print up $100 million.
Mr. Chairman, just to respond to that, Representative Banks referred to some work that was being done by members of the committee, led by myself, of developing those acreage for a swap. Because while I agree with you, we're in a difficult spot when we talk about our fiduciary duty. If you're taking that in literal terms, it would be for maximum value. But I think for me and many members of the board, there's value in protecting the Kelly parcel for its location, for its recreation value, for the migration location. And so for me, the win-win was developing that. And so what we had come up with that was equivalent value of that 100 million was working out to be about 120,000 acres in the Powder River Basin that was developed based off of the disposal list, but then built out and contiguous to other state land. And so that's why I think I'm so passionate about this, because I truly believe that we could have gotten that across the finish line, especially with this incoming presidency. And so 640 acres for 120 in the Powder to develop seems like a better deal to me.
Representative Davis.
Megan, I don't know why, I can't get over the rest of your title, but Megan is the easiest. But what tools can we, or as legislators, help in this process? If we feel strong about this, what tools or can we put on the table to help, let's say, change some of the regulations or something to entice us to get some traction, I guess is the word, as we're going forth? Is there something out there that you can, advise the Ag Committee on that we could take into an interim topic or something like that?
Mr. Chairman, Representative, I think this bill is a good step. I hesitate to take away authority of the Board of Land Commissioners. It's our constitutional duty. And so that vote was taken and it passed. And that was aligned with the process. I think further working with the Office of State Lands, I want to continue to do that. It can be, difficult depending on, how that office is lined up and serving the board. But I think that, I'm committed to doing that. I think partnering with members of the Board of Land Commissioners to move that work forward. But I think that this bill is a great step.
Yes, thank you. Appreciate your
Thank you.
time. And
Thank you.
State Lands, come up, please.
Morning, Mr. Chairman, committee. My name is Jason Crowder. I'm the interim director for the Office of State Lands and Investments. I appreciate the opportunity to be with you this year and this morning and to speak to this bill. Greatly appreciate the opportunity to speak right behind a board member. That's always a great position and comfortable position for me to be in. But greatly appreciate Superintendent Degenfelder coming in and providing you her thoughts for this important topic. I want to speak to the bill first and then answer any questions that you have about any real estate transactions that we've most recently completed or that we have underway at the moment. But what I do want to highlight is something that the superintendent talked mostly about, and that's the fiduciary responsibility of the Office of State Lands and Investments. The Board of Land Commissioners obviously has a constitutional duty to the beneficiaries that it serves, but we have a fiduciary responsibility to the Board of Land Commissioners to provide them with the best information that we can to put transactions together that have that greatest benefit we feel that we can provide to the board to make their decisions. So in that vein, we have rules and regulations. We also have statutes that have been provided to us, and they're a little contrary to what the intent of the bill is. Obviously, we are a revenue generating agency. We try to optimize the amount of revenue coming off of those lands, but we're also charged with protecting the value of the corpus. So not just the value of a specific acre, but the value of the whole corpus put together and increase that value if we can. And land transactions are the best way for us to do that. Appreciation, natural appreciation also does it. But if we could advance that and accelerate it through land transactions, that's one of our core missions. The statute specifically, Statute 36-1-111, says that we can do land exchanges on a value for value basis. So it puts in that principle of value for value instead of acre for acre. And that's how we've done every land transaction that's been completed. And that's how the Board of Land Commissioners has developed its rules underneath that premise of value for value. When we talk about doing transactions with the federal government, they have the same requirement. That comes to them as a requirement under 43 USC 1716, which is their federal land exchange policy and rules. So every time we have a conversation with the federal government, it's not acre for acre, it's value for value. And that ensures that the value of the corpus that the state is in charge of, that the Board of Land Commissioners is in charge of, remains the same for the benefit of those beneficiaries, but the federal government has the same desire. They don't want to be hung out to dry, just like we don't want to be hung out to dry and receive lower value lands just because the acreage didn't work out or we needed more or less acreage in any scenario. I think some of the impacts to that fiduciary mission that we have based on the bill is a loss of opportunity. Obviously, The Kelly parcel was brought up, and I'm happy to answer any questions about that. But from a fiduciary standpoint, the impact that that parcel had, or the sale of that parcel had, was a net positive to the state's trust beneficiaries. And we only had that opportunity because we had a willing buyer at the other end, which was the federal government. So if that willing buyer is no longer eligible to be at the table because of the acreage discrepancy, then we don't have that opportunity anymore to have that benefit for the beneficiaries. And I also want to highlight that every transaction is unique. We talk about the Kelly parcel, but it should be talked about by itself and not compared to others. We talk about the Medicine Bow Exchange, but it should be talked about by itself and not against any others, because they all have unique attributes, unique benefits to the state of Wyoming and to the beneficiaries. And every one of those that we push forward with a positive recommendation for sure to the Board of Land Commissioners for consideration has an opportunity for that benefit. And if we can't do that because of an acreage discrepancy, we lose that opportunity. There's an opportunity cost there. I want to talk about history for just a second. We participated in an effort with the county commissioners of every county across the state through the Wyoming Public Lands Initiative. That was an initiative to understand wilderness study areas specifically, but they also looked at wilderness areas of getting lands that are trapped, particularly state lands that are trapped inside of those federal protective designations, and move them out to something that we could actually utilize. We could generate revenue from, or we could do a real estate transaction of some kind to derive that benefit. There was a lot of effort and work that went into that, and it was kind of a notice to the federal government that we don't want to be trapped inside of your either formally designated areas or study areas, that we need to be moved out of that. And I think it was a great effort, but it leads into what I want to use as an example for an impact of this bill, which is the Medicine Bow Exchange. We are currently working with the Medicine Bow National Forest to do a land exchange to further a couple different benefits. One is development of the West Fork Reservoir, which will benefit irrigators downstream with more consistent water. They can't build, the Water Development Office can't build that reservoir on federal lands without a lot of more process, and from what we understand will be something that has a lot of roadblocks put in front of it. But it can be built if it's private or state lands. State lands in this example is the direction we're heading. The other benefit is the lands that we currently own within the Medicine Bow National Forest are trapped within that forest. They're isolated based on topography. We really can't even go and harvest timber in there because the topography is so steep and difficult to get in. But they're also trapped by the wilderness areas within that forest. And so we're quasi under the management authority, if you will, of the federal government of those wilderness areas, because we can't get in there, we can't move them. And so the only way to get out of that, it might be oppressive from an income standpoint, oppressive management action by the federal government is to remove our ownership from there and go somewhere else. So those two benefits have come together in this land exchange to find a piece of property that makes sense for development of the West Fork Reservoir, but also move our ownership into something that we can more readily manage. We can get to from a timber perspective, the public can get to from a recreation perspective, and we can further develop some commercial opportunities out there for recreation, like boat ramps or anything else. Or this is an extreme example, but the opportunity a long ways down the road is for some type of hospitality. I won't say a hotel or anything, but something close to that the beneficiaries can benefit from a revenue standpoint. That transaction, and the only way to get it done in a value for value scenario is that we bring more state acres to the transaction than federal acres we will acquire. And that's truly or totally based on the value of those acres. Again, our acres are trapped. You can't get there. They're trapped by topography or designation. But the acres the state would acquire are along a highway. They have access, which increases their value, which means to do the value for value scenario, we have more state acres involved in that than federal acres. And the federal government will acquire more acres than we will acquire in the transaction. But we get a very large benefit out of it. So we feel like it's something that benefits the beneficiaries, and we're moving forward with that. Should the bill pass, that transaction will be dead. We couldn't move forward with it because the federal government will be gaining more acres, and we'll have to stop analysis of it right there. So I just wanted to raise that as an example. Again, it should be reviewed and analyzed of its own merits, not really compared to any other transaction because they all have their unique attributes. The other thing that I'll mention is, along with those unique attributes, we're looking at the Black Hills National Forest, and doing a land transaction up there in Crook County. That net result, should that go forward, and again, it's just in the very infancy of discussions, but should that move forward, the federal government will receive less acres than the state will in that transaction, and what may largely equal out between the two forest transactions over time. And so that's how we like to look at it. Over time, what's the net impact instead of transaction by transaction? The question was brought up about state acreage. I want to answer that real quick for you. At statehood, the state was granted 4.2 million acres. Since then and currently, we own 3.9 million 3.4 million surface acres and 3.9 million subsurface acres. So some lands have been disposed of. It was done early in the state to kind of populate the state's coffers. Recently, we've had nothing but a net increase in publicly accessible acres, revenue derived out of that. Again, we're looking for nothing but positive benefit in all these transactions, so a net increase in all of that. It's important to note, back in 2005, I believe, I'm losing my years, but the legislature told the board there should be no net increase of state lands, and gave us a threshold based on a total acreage under ownership in 1999, and not to exceed or go under a 10,000 acre threshold there. Right now, we're 3,300 acres under that threshold from that baseline in 1999, but I hope that answers your question. 4.2 down to 3.4 right now for surface acres. Mr. Chairman, that's what I have for you. I'm happy to answer any questions. I failed to introduce Cody Booth, who's sitting on my right. Cody is our Assistant Director for our Trust Land Management Division, so I apologize for that, but we're happy to answer any questions.
I have one question for you. Do we need to amend this bill to accommodate the needs of the state?
Mr. Chairman, what I believe the bill does is changes the direction and introduces a conflict within statute. So that right now our direction is value for value consideration. This changes it to have a conflict of acre for acre, or could at that point. So I don't know if I can offer a change right now. I'm happy to work with the committee and the bringer to find a solution there, but that's a fairly large paradigm shift for how the office does land transactions with the federal government.
Thank you. Anyone else have questions? Representative Johnson.
Mr. Chairman, this transaction, municipal, is going to be this spring. Is that correct?
Mr. Chairman, Representative Johnson, it is a transaction with the federal government, so it takes some time. We have gone through an immense amount of effort to review the impacts of the reservoir, as well as review the impacts of the land exchange. We almost have the feasibility analysis completed by the Forest Service, that part of the transaction done. Once they've completed that for us, and we expect that in the next month or two, then we can get into the actual transaction process, which could take anywhere from a year to maybe 18 months before we can close on that. But again, it's with the federal government, it's with the Forest Service, and it's always a struggle no matter what parties on the other side of the table. But right now, the Forest Service is going through very large budget reductions and very large budget problems. And their ability to put resources and staff to this transaction has been limited. So we've been trying to backfill as much as we can, but it slows the process down, certainly.
One more follow-up. With the Trump administration, do you think we'd have a better deal later on? I mean, just the change of administration and the way the interior of the country is going to be managed?
Mr. Chairman, Representative Johnson, I don't know if I have a great answer for you on that. The Forest Service inside of their real estate transaction rules has remained fairly consistent, administration to administration. They've been very good to work with in this transaction. It's just there are a lot of analysis and steps in the process that are out in front of them to work through. So I guess it's yet to be seen if the next administration can help streamline something. I don't know if I see a change in the next 6 months, but it's yet to be seen, I guess.
Thank you, Mr. Chairman, Director Crowder. What I'm interested in, and a lot of it might be background, but as far as the Lands Initiative and the conversations with the counties, there's been a lot of land, or in my view, a lot of land put into wilderness study areas. And with my understanding, I thought that those were supposed to be termed out or expire at a certain point. If we follow up on that, I mean, can it be done? Can it be encouraged? Or how does that, how would that affect the streamlining of what we're able to do?
And Mr. Chairman, Representative Ottman, again, I don't know if I have a great answer for that because I'm not totally involved in that world on a day-to-day basis. The whole impetus behind that initiative was to get the federal government to decide what it was going to do with those wilderness study areas, to make a decision, either make it wilderness or not, and let whatever management actions that could occur outside of a designation occur. I do think it's important to note that they're wilderness study areas for a reason. They exhibit attributes that demand study, probably may need some protection going forward. But the whole impetus behind that initiative was to get them to make a decision. Where they are in that process, I can't answer that for you, and I'm not sure how to give you some tools to move that forward. But we're happy to look into it because we see a restriction in our fiduciary responsibility by those being in place and did participate and would participate in anything going forward. Again, though, it's important to note that situation by situation, parcel by parcel needs to be understood. There are times when we are making money, conservation type leases inside of those areas, that if they were not designated, we might have a limitation on revenue generation. So again, you have to look at every parcel, but on the whole, happy to participate in that again.
Go ahead. Go ahead.
Mr. Chairman, again, with those conservation agreements, are those into perpetuity or do they have limitations on them as far as how long?
Mr. Chairman, Representative Ottman, great question. They do have a limit on them. Typically, it's 25 to 35 years is the length.
Do we have any more questions? Thank you, Mr. Crowder.
Thank you, Mr. Chairman.
Does Representative Tarver have a question or a testimony?
Good morning, committee. Mr. Chairman, I'm in full support of this, and just listening to Mr. Crowder's testimony, wouldn't it have been nice if we would have had a parcel that had a lot of value that we could have used to trade? And something else here. So acre for acre or value for value, I don't know if that is in that bill yet or not, or how it is laid out in that bill. But I would recommend maybe we do something even better than that. A 10 to 1 or 100 to 1 to our advantage, not the federal government's advantage. I don't see where the federal government manages absolutely anything very well. Something else the Mrs. Ahmed was asking, the wilderness areas. What they are really good for is making tinder for fires through their mismanagement. It just, everything they touch turns into a problem for the state of Wyoming. Thank you for bringing this bill, Mr. Banks. We need to do more. Thank you.
Thank you, Representative Tarver. Yes.
Thank you, Mr. Chairman. Representative Tarver, would you, if this bill keeps private property owners from being able to sell their land to the federal government, would you be in support of infringing on their rights to do so?
Absolutely. Any more?
Anybody else have questions? Okay, thank you, Mr.
Thank you.
Representative. Do we have any more testimony? Mr. McGagnon, please come up.
Thank you, Mr. Chairman. Jim McGagnon with Wyoming Stockholders Association. We stand in support of this bill, but would suggest for your consideration, I'm not sure if this would take additional language because of the interpretation of exchange. So to use the example, I believe that was brought to you by the Office of State Lands, you may have an exchange based on value where the federal government would, in the exchange itself, acquire more land than the state would. But if somehow this could be worded that no exchange, X other sections without net gain right to the federal government unless it is accompanied by a firm agreement to transfer additional lands from the federal government to the state equal to the acreage that is given up in the exchange, or some language like that to say you could have the actual exchange be value for value, but we would only execute it if there was an additional agreement by a federal agency to transfer acreage to the state directly outside of the exchange itself, but at the same time so that there would be no net gain of federal lands. And whether that would take some, perhaps a little additional wording here, I just haven't had time to really give it thought what those words might be, but to be able to preserve the ability to do value for value exchanges, but not do those if they're going to result in any net loss of or any net increase in federal acreage in the state. Because I think that is, we believe that is critical. Yes, we can do some exchanges that benefit the state in terms of potential future revenue generation from minerals or from high value surface. But if we're doing that at the expense of putting more surface acreage into the hands or mineral acreage in the hands of the federal government, then we believe that's not appropriate for the state of Wyoming to do that. With that, Mr. Chairman, I'd be happy to answer any questions.
Representative Ottman.
Mr. Chairman, Mr. McGagnon, I'm not sure if you're the person that can answer this, but I think possibly. Do you see that conservation easements are a gain in control by the federal government?
Mr. Chairman, Representative Ottman, I do not, because conservation easement, the only federal engagement in most of those is that some of the funding for them, if they're purchased easements, may come from the NRCS or something, but the control that the easement grants, the property right that the easement grants rests solely with the conservation entity that is acquiring the easement. And since we do that ourselves through our Stockholders Land Trust, that's a good example, for example, and we don't have any ability, nor would we ever consider to transfer any of that ever to the federal government. So I don't believe that that's a real concern. I understand that why it would be concerning if it could happen, but I don't believe that that's a concern. Those would be transferred depending on what the agreement, the terms of the individual conservation easement are. Now, I go back in time, I do recall when some national entities acquired some conservation easements and then transferred that land over time to the federal government. I can assure you that the lands that we acquire, that would never happen, but I think that's the importance of the terms of the easement and the confidence that a landowner has in the entity with whom they enter into an easement.
Thank you.
Any follow-up? Okay. Anyone else? Thank you, Mr. McGagnon.
Thank you, Mr.
Could we have our Zoom?
Kelly is
participant?
online, yes, and if you go ahead, Kelly.
Yes. Welcome, Kelly.
All right, can you hear me again?
We can.
All right, thank you. Thanks again, and good morning again, Mr. Chair, members of the committee. I will be brief in the interest of time. Kelly Carpenter, Wyoming Farm Bureau. Sit in support of this bill. Our membership has several policies supporting no net gain of federal land that fall in line with this legislation. So thank you again, and I will take any questions you or the committee may have.
Do we have any questions? We do not, so thank you, Ms. Carpenter.
Thank you.
Is there any other testimony out there that we need to hear from? If not, what's the pleasure of the committee?
I'll second.
Okay, the bill has been moved and seconded. Should we have a discussion? Okay, I guess we're ready for I'm sorry, go ahead.
Thank you, Mr. Chairman. I think my one question would it be valuable to go ahead and change what, the value to value rather than acre to acre? If that is the problem, just wondering how that would help or not.
Yeah, I think we need to consider that. Maybe we need to address it at the next meeting.
Okay, thank you.
Is that preferable to everyone? Okay, let's not vote on it right now and just. Oh. Okay, you're right, thank you. So can we have a roll call vote? Okay. Representative Provenza.
Thank you, Mr. Chairman. I just, maybe I spent too much time on judiciary, but looking at this bill, and I believe Representative Banks said you didn't think that this had anything to do with private property rights, but when you look at Title 34, so Section 1 does limit private property owners from making decisions, which I then, our United States Constitution has our takings holdings, and so does the state of Wyoming's constitution. Private property shall be taken for public use with just compensation. So private property rights, and we talked about this in the last bill, the Supreme Court has said that property rights are necessary to preserve freedom for property ownership. They go on to say, but basically it's all to say, you have the right to do what you want with your land, to sell it to who you want for how much money you want to get from it. And so I think this is an infringement on the takings clause of the United States Constitution and the Wyoming Constitution, and infringes on people's rights. Aside from that, Mr. Chairman, I hear the concerns about the federal government. I share some of those. I really do. But I think about how I've used public lands in Wyoming. They put food on my table. That's where we hunt. We have a constitutional right to hunt and fish in Wyoming. These lands that have been managed by the federal government, we might disagree with how they have been managed, and I think we can continue to have debates about how to deal with that issue. But when we say we want to limit federal land use, I think about where I want to raise my children, where I want them to learn how to hunt, where I want them to camp, where our ag community raises their cattle. So I get it. We want to shake our fists at the federal administration, but I also think that for the average person in Wyoming, they just want the freedom to access their public lands. And I think that this is going to get in the way of it. So I'm a no vote on this bill.
Okay.
There's no other discussion. I'll call for the question.
What do we need to do to vote on this? let's go ahead and have the roll call then.
This is voting on House Bill 118. Representative Banks.
Aye.
Representative Davis.
Aye.
Representative Eklund.
Aye.
Representative Johnson.
Aye.
Representative Ottman.
Aye.
Representative Provenza.
No.
Representative Schmid.
Aye.
Representative Strock.
Aye.
Chairman Winter.
Aye.
Vote is 8-1.
Thank you, Mr. Secretary. I guess anyone want to make a motion to adjourn? Second?
I'll second it.
All in favor, say aye. We're adjourned.